On January 29, 2022, Boston police officer John O'Keefe was found unresponsive in the snow outside fellow officer Brian Albert's home in Canton, Massachusetts. His girlfriend Karen Reed was later charged with second-degree murder, manslaughter, and leaving the scene of a fatal collision. Prosecutors allege that after a night of drinking, Reed dropped O'Keefe off at Albert's residence around 12:30 a.m., then struck him with her SUV while backing up, leaving him to die in the snow. They cite evidence including fragments of her broken taillight found near O'Keefe's body and a timeline containing digital evidence from John O'Keefe's phone and from Karen Reed's SUV. The defense counters that John O'Keefe was beaten inside the house during a party and his body staged outside to frame Karen Reed. They highlight investigative misconduct, including the use of inappropriate evidence collection methods and potential conflicts of interest due to close ties between investigators and the Albert family. And now, all the evidence is in and the anticipation is high on this, the eve of closing arguments in the retrial of the century. I'm Vinnie Politan. Thank you for joining us tonight here on Closing Arguments. Wow. This is the time that is probably the most anticipated and the most anxious when we're covering a big trial here on Closing Arguments. We call it Closing Argument Eve. That's what it is. It's the night before. It's the night before closing arguments, and all through the courthouse, not a juror was stirring. But what about reasonable doubt? That's the question tonight. Tomorrow's the day, the last opportunity for the prosecution to erase the doubt, for the defense to raise a doubt. It's big. In a trial that is 2 months long, with all this evidence and all these issues, each side has their final opportunity to put it all together. Now, we named this show Closing Arguments because we know how important closing arguments are. So welcome to Closing Argument Eve. For Hank Brennan and the prosecutor, what he needs to do is provide a roadmap to conviction. He has to. When I've seen prosecutors fail here on court TV, it's when they argue a lot of issues, but they don't give a specific roadmap to the jury, a way for them to get from point A to point B to point C, which is the conviction. And that's what he has to do. You've got to focus, obviously, on the evidence, but you've got to focus on the charges and the elements of the charges and how you have proven them in one or more ways. It's a daunting task as a prosecutor because you know the heavy burden you have. But prosecutors choose to bring the cases. They don't choose to bring cases they don't think they can win. So now you've got to put it together, but you've got to give this jury a roadmap. So when they get in that jury room, okay, we know what we have to do, and his words are resonating in your mind. Like, oh, to prove second-degree murder, they've got to do X, Y, and Z. Well, how did they do X, Y, and Z? He just told us. That's what he needs to do. Alan Jackson and the defense, they've got to show the doubt. Show the jury all the places where the reasonable doubt is. You know, there's several different ways that lawyers do this. A lot of them, there's this standard chart that a lot of attorneys around the country use. It's a demonstrative aid, and it kind of shows you what reasonable doubt is and what reasonable doubt isn't. It's extremely effective. I don't know if they'll use it. They may not. But that's the point. Like, there's just one point of a closing argument for the defense, is to show the jury that there is doubt in as many places as possible, but specifically to undermine the roadmap, to undermine the proof relative to the elements of the crime. Again, the level of proof that you have to show is much less as a defense attorney, but it's not necessarily easier. And again, it's because the defense doesn't choose what cases they're going to try. The prosecutors decide when they indict suspects and defendants. So the bottom line for me, and this is the biggest question lingering here on Closing Argument Eve, is will they get it done? Not the lawyers, but the jury this time. Will the jury this time get it done and agree and fill out the paperwork properly. So the families of the family of John O'Keefe, the family of Karen Reed, and the prosecutors, the attorneys, and the community can all have some definitive word from the only 12 who matter at this point, which is the jury. Well, there's someone else who matters. Court TV crime and justice correspondent Matt Johnson, who is live tonight outside the courthouse in Dedham, where he has been living for a long, long time now. It seems like 2 years he's been up there. So as we're here on closing argument eve, and one of the things that usually happens during the day is the charge conference. So what can you tell us about today's charge conference?
Charge conference actually went smoother and less amount of time than we had expected. You realize this time tomorrow we're either going to have a verdict or we're going to be in verdict watch, and a big part of that is the verdict form. So the defense was really trying to make some points today and argue that the verdict form, in their opinion, should be modified or changed. This after several jury members came forth last year and said that there was a consensus on two of the top charges, and that they voted not guilty, but they were confused in the courthouse here behind me. Well, today the defense team was talking to the judge about it, and here's her reaction.
And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal clear.
Karen, how we feel on the eve of closing
verdict form? How important is that to have that verdict slip right?
Very important, as I learned the hard way.
Defendant Karen Reed on the courthouse steps there telling us that she has butterflies. She also did last year, and she feels that she has a very strong defense, and she's looking forward to the jury getting the case. When they do, take a look at this video. This is new to our newsroom. It's the video of all of the exhibits and everything that's going to go back to that jury room here in the courthouse behind me. All of the boxes, the clothing, all of the pieces of taillight, all of those exhibits. And there on the end is brand new this year for this second jury of the retrial. Those are big blow-ups of the x-rays that show no fractures or broken bones of victim John O'Keefe. So there's a lot to consider, and the judge has made it very clear to all parties during the charging conference earlier today, Vinnie. She wants this jury to start deliberating tomorrow. She's going to allow them to work later than normal, up to 5:30 in the evening.
Okay, 5:30. I guess that's late for Massachusetts. I know you've covered cases down in Florida. We've covered cases in Florida where they go, to midnight, but to 5:30, that's a full day. So let's talk about the closing arguments. What are the expectations, and are there any limitations, like time limitations, on what they can do?
There are, and this year is going to look a little bit different than last year if you followed that trial. Last year it was Alan Jackson and it was Adam Lally that delivered those closing arguments. Adam Lally ran out of time, remember that? Well, this judge is a stickler on time. Yet again, she is informing these attorneys that they're only going to have an hour and 15 minutes to make their closing remarks to the jury. This year it's going to be Special Prosecutor Hank Brennan for the Commonwealth and Defense Attorney Alan Jackson. Now, the state is expected to bring up statements of the defendant, and the defense is expected to argue a Bowden defense, which is allegedly faulty police investigation, or that they didn't look into all possible suspects after not meeting their burden for a third-party culprit. The judge talked about that earlier today as well. Take a listen.
I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a potent defense.
And that was David Yannetti. He was in court today doing much of the arguments along with Robert Alessi. Alan Jackson was preparing back at headquarters their closing remarks today. But we were able to get this out of David Yannetti as he exited the courthouse. How are we feeling going into closings?
Feeling great.
Again, they were all smiles leaving the courthouse, and we can't stress it enough. This judge will stop them at 1 hour and 15 minutes, and one of the parties ran out of time last year.
I remember that. It was unreal. I'd never seen anything quite like that before, but we experienced it. Okay, how would you describe, because you were there last year, the mood at the courthouse?
Well, the mood at the courthouse has very much changed. We're seeing a lot of more supporters of Karen Read, and they're closer to the courthouse. They line up. They were cheering for them as they would exit, but now they're standing and supporting them in silence. This is video that I took off my phone earlier today after the defense team and Karen Read got into their SUV and they drove to their headquarters. But we also met up with one of the supporters that was here last year, one of the organizers, Rita Lombardi, and she had this to say.
So I'm cheering like this, and I believe in justice. I believe in the American justice system, and I believe this jury will come back with the right verdict. I believe they would last year. This year, I'm even more convinced. I believe we'll have a verdict by the end of the day tomorrow. And if we don't, it will be by Monday. This jury is not going to take long. This has always been about justice for John O'Keefe. But Karen Read did not kill John O'Keefe. Karen Read is an innocent woman that has been framed. So before we can ever get justice for John O'Keefe, we have to free an innocent woman. And then we can get justice for John O'Keefe. Justice will not happen convicting an innocent woman of a crime she did not commit.
And these supporters say that they're going to be out in number in force tomorrow. And that's something that we saw last year as well. It took a few days for that verdict watch that led to mistrial last year, as you know. But the numbers of people grew. The numbers of supporters, the numbers of protesters that are anti-Karen Read, as they put it, or there were another group of people that were supporters of the O'Keefe family. We saw them towards the end of the verdict watch. And then we just saw a lot of onlookers and added members of the media from all across the country that were here. So we can expect to see that probably tomorrow. And again, they grow in numbers as the hours move on in a verdict watch.
Yeah, the media, Johnny-come-latelys always show up at the end. We're there the whole time, though. Matt Johnson's there the whole time. Thanks so much, Matt. Big day tomorrow again. Could be the biggest. Thank you so much. Let's bring in our Karen Read insiders. Joining me tonight, longtime Massachusetts attorney. He was a homicide prosecutor in Norfolk County, Rick Grundy. Former prosecutor Margaret McLean is with us. She's also the host of It's a Crime with Margaret McLean, along with criminal defense lawyer Sydney Rushing and journalist Rebecca Lavoie. She's also the host of Crime Writers On podcast. Great to see everyone. Happy closing argument eve. We celebrate it here on this show. When we have the big trials and it's the night before, we get ready. So this is a retrial, right? I've been calling it the retrial of the century. So this is what I want from you to start tonight. Who did better second time around? Who's in a better position right now than they were last year, the prosecution or defense? We've got a lot of ladies here tonight, Rick, so we'll go with you first.
So the sequel of either side beats the original of the other side in both cases. But between the second version of the defense and the prosecution, I think it's a very difficult call. I think the prosecution overall put together, developed from where they were, personally, their side, developed did more development and put together a better case. I think the defense's real progression was in trimming down their case and focusing their case. I think they made alterations. The prosecution tore down and rebuilt.
Okay, so that makes sense. It makes total sense to me. Okay, so you've got prosecution has the upper hand here. All right, Sydney, who has the upper hand here second time around as we sit here waiting for those closing arguments tomorrow?
So I think this time around, I have the upper hand. And the reason I say that is because in the first trial, there was a lot of weight put on this third party thing, right? And I think this time around, they were very concise and they were very meticulous about the witnesses that they called. The witnesses that they called were all strong. They said the complete opposite of what the Commonwealth said. The only difference was all of the Commonwealth's witnesses were nearly impeached and shown to be non-credible, yet the witnesses on the defense side were shown to be credible. And not only that, with the ARCA experts coming in, that they were unbiased and that they were hired by someone not even involved in this and came to their conclusions prior to even coming to testify, I think that weighs heavily. So I think the defense is in a better position this time around, and I think that they're going to see success.
Okay, and it's almost like Noah's Ark came in to save the defense. Margaret McLean,
Right.
as we sit here tonight, who's in a better position compared to last year, the prosecution or defense? Who did better second time around?
The prosecution with its facts, science, and data. Absolutely. New timeline down to the seconds of when John O'Keefe was struck by Karen's car.
Are you troubled at all that you had to say new timeline when we're talking about the prosecution?
No, I'm not.
Okay.
It's a new jury.
Okay. I'm always uncomfortable when prosecutors in a second trial for the same case change a theory. We had a case years ago where they charged these two young boys with a murder, and then after their trial, they then pointed the finger at somebody else. I was like, how do they do that? But they were allowed to. Okay, I get it. New evidence also they had, right? More digital evidence this time around. Rebecca,
Absolutely.
who's in a better position tonight? Who did better second time around, prosecution or defense?
For me, it's not a close call. I think both sides did better, frankly. I think that Hank Brennan is a stronger lawyer, did a better job with cross-examination. However, the 1-2 punch at the end with Dr. Lopezada and Dr. Rentschler, looking at those x-rays, I think that's an incredible way to go to closing arguments. It makes it, as Rentschler said, you can't put the cart before the horse and put all this ancillary stuff on the table unless you have proven a collision. And I think the defense did an excellent job disproving the collision.
Okay. Next thing, we're going to go around the horn real quick, about 20 seconds each. Give me a number 0 to 10, how important these closing arguments are tomorrow and why. And we'll go counter this time. Rebecca.
I'd say 8.5, largely because it's going to be the story, right? It's either going to be the obtuse data story that can turn into a concrete story, or it's going to be a narrative of what did or didn't happen. And I think that Jackson probably has the edge there. But either way, it's pretty critical what happens tomorrow.
Margaret, 0 to 10.
0 to 10.
I would give it a 9 because it was such a long trial and both sides really have to package it for the jury.
Sydney, 0 to 10.
I always think closing argument is the most important. That's actually where I start in trials, is my closing argument. So I think it's a 10, and it's because this is where they're going to put together everything from almost 50 witnesses in 8 weeks of trial. They've got an hour and 15 minutes to tie it up.
Rick Grundy, 0 to 10.
I'm going to follow up with a 10 as well, for a little bit different reasoning. I think the length of the trial, it makes your closing that much more importantly. If you can grab them with your opening in a more of a week to maybe 10-day trial, I think the opening is more important. But in this case, it's, particularly the way it was segmented. Now, that you could feel a tide change. Everybody was like, Hank's doing a wonderful job. Look at this. The prosecution didn't pull any of this. And then all of a sudden it became the expert show. I'm not so sure that the jury has been as impressed with the experts as people who are watching TV coming and going are. But Hank Brennan has to use that opening to get back to I hit him, get back to the niece's testimony, get back to the first responders' testimony, and focus in on that stuff that really hits a jury hard, things that they understand, the spoken word. That's,
all right.
That's a task.
That's a task. So I have a task coming up, right? This is another tradition here on Closing Arguments. We like to do this when we can on Closing Argument Eve, is give you a mini closing argument. And we ask our guests, and some decline, but not all of them do. Margaret McLean, when we come back, I need you to deliver not the full hour 15, but maybe the 3-minute version, like the Law and Order closing argument for the prosecution. We will see that when we come back, and then we'll talk about it. Plus, coming up next hour. Tonight on Vinnie Politan Investigates, the retrial of the century is coming to a close. All the evidence is in, but is there enough to convict Karen Read, or has the defense raised a reasonable doubt? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
Karen Read is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
The Karen Read Murder Retrial. Live coverage weekday mornings, 8, 7 Central on Court TV.
There's another years and years ago. Started practicing in Norfolk County in Braintree, what is now Quincy. I eventually became a far smarter man than myself. Eventually became President of the United States. His name was John Adams. John Adams once wrote, "Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lrae, I have to stop you. You've gone over. Okay.
I literally have one sentence on you.
That's how it ended last time. And then the jury got the case. He ran out of time. What we're going to do right now is give you a condensed version of a potential closing argument for the Commonwealth of Massachusetts in this case. We've got our insiders with us, and presenting the argument for the Commonwealth's case, former prosecutor Margaret McLean. Margaret, thank you so much for doing this, first of all. 3 minutes. We're just going to give you 3 minutes, so it's more like when you watch Law and Order and you see those closing arguments. Boom, 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 boom. Are you ready?
Yes.
Counselor, proceed.
The facts, science, and data in this trial has proven that the defendant, Karen Read, struck her boyfriend, John O'Keefe, with her Lexus and left him to die alone in the cold during a blizzard on January 29th, 2022. As John O'Keefe stood by the side of the road outside 34 Fairview, the defendant, Karen Read, knowing he was standing there, pulled her Lexus forward and then slammed her foot down hard on the gas pedal up to 75% throttle and drove in reverse at least 70 feet in the direction of her boyfriend, reaching a speed as high as 24 miles per hour when she struck him. She hit him. And then what does she do? She just leaves him there with a fatal head injury, a broken skull. And then she drives away. And that's exactly what happened, according to the hard data from John O'Keefe's cell phone and Karen Read's Lexus. You heard testimony from Shannon Burgess that the backup maneuver on the Lexus occurred between 12:32 and 4 seconds and 12:32 and 12 seconds. John's iPhone locked up at 12:32 and 9 seconds, and that phone remained under his incapacitated body. The healthcare and location data from that phone proves that it remained underneath him until 6 in the morning. It didn't go anywhere, and the data shows the cell phone battery dropped in temperature because it was so cold outside. This timeline can't be disputed. I mean, according to Dr. Welcher, the injuries on O'Keefe's arm are consistent with being struck by the defendant's taillight. And the forensic evidence recovered at the scene in the very vicinity of John's body came from the defendant's taillight. John's DNA was on the back of the car along with a fragment of glass from the cocktail glass that he held in his hand. Ring camera video also reveals that Karen's taillight was broken when she backed out of John's driveway at One Meadows at 5 in the morning. In addition to the facts, science, and data, you also heard hateful voice messages from the defendant directed at John after she left him to die in the cold. She also left a message, "John, no one knows where you are." But isn't it interesting she hadn't asked anybody at that point where he was? You also heard admissions from the defendant herself. At 5 in the morning, the defendant's frantic. She calls Jen McCabe and says she left John at the waterfall. Then she wonders if he got hit by a plow. I mean, that's convenient, isn't it? She also admits she was so drunk that night she didn't remember anything. And she points out her broken taillight to both Carrie Roberts and Jen McCabe. And then all three women head over to 34 Fairview. Then, one of the most telling actions by the defendant is when they arrive at 34 Fairview, she bangs on the car, yelling, "Let me out, let me out." And at that point, she jumps out and beelines over to the far corner of the property near the flagpole. I mean, it's still pitch black out. She goes directly over to where John is lying, covered in the snow, his cell phone underneath him. Ask yourselves, how did she know he was there? There are two other witnesses also say couldn't see that two other witnesses couldn't see a thing, yet the defendant knew exactly where he was. You also heard from a number of witnesses at the scene.
We're out of time, Counselor.
Okay. Who heard her say, "I hit him, I hit him, I hit him." Finally, I submit to you, after you've reviewed all the facts, science, and data, there's only one verdict you can return, and that's a verdict of guilty on each and every count of the indictment.
That was fantastic, by the way. First of all, it's fantastic. Fantastic. It's not easy to do.
Run out of time.
You're taking a 2-month trial into 3 minutes. It's virtually impossible to do. The notes that I was taking here, I thought it was really significant, and I think it would be the right thing for prosecutors to do here, Rick, is to start with the collision. Because they need to prove the collision. This jury, that's an element of all the charges against her, that she causes the death. She causes the death with the collision. So I love that Margaret started with the collision and then was demonstrating the evidence that supports that. What are your thoughts about starting there? That, hey, this collision happened and she is responsible.
Yeah, I agree with you, Vinnie and Margaret. I actually, in thinking this the last several nights through, that being in reverse is the one thing that I really don't think the defense experts touched upon. That car was in reverse. It was in reverse at a high speed for a significant period of time. And I haven't been able to watch the entire, I didn't check in with Nick Rocco on this, but I don't think the defense addressed that, and that's huge.
Yeah. So what I'm going to do here, Sydney and Rebecca, I'm going to let you guys kind of let this all sink in, because you're going to be responding to it first in your argument and then in the conversation. Margaret, what I also found interesting, when I think about this and what prosecutors have to do to prove that collision, I look at it that they can do it 3 ways, one of 3 ways. They can do it through the expert testimony, they can do it through Karen Reed's alleged admissions, or they can do it through the physical evidence. And I personally think of all 3 in the second trial, based just on what was in this courtroom, I felt that the forensic evidence was the strongest of the 3, which is the taillight evidence. And I understand that there are explanations for it, et cetera. But in this trial, Trooper Proctor was never on the witness stand. In this trial, there hasn't been that same theme that existed in the first trial. In the first trial, all we were talking about was, did he plant evidence, did he not plant evidence? In this trial, that really hasn't been a big piece of it. So I think by leaning on the forensic evidence, is huge. Is huge. The expert, I think, just is confirming. I think there's a true battle there, and then the statements are similar to last time. The only thing I would have added, because I think it's different, because last time the jury wasn't convinced by just her alleged confession. At least 3 of them didn't believe that she confessed, were the added interviews with the media. And those can be interpreted different ways, but I also felt like the defense didn't do much to rebut any of that. And the only person who could have rebutted it was Karen Read herself by getting on the stand and explaining and giving more context to all those statements. But I thought this was masterful, the way you put it together and touched everything. What are your thoughts about how large a role drinking should play in all of this? Relative, like I know it's a big part of count 2, but if you overplay it, does the jury immediately go to count 2? Or do you think you can make the argument that she's drinking, she's under the influence, and she's committing murder?
Yeah, I mean, when I felt, that's why I started with the second-degree murder count, as you can tell in my opening statement just now. But I think the evidence is very clear. They'll see for themselves that she was clearly intoxicated beyond the limit, beyond .08, and she admitted herself that she was in a drunken state when she pulled glass out of his face. So I think that the key is to focus on the second degree, the collision. We have to prove there's a collision, right?
That's the bottom line. That's the bottom line. I mean, that's the bottom line. That is the common denominator for all the charges. If you don't prove the collision, she's walking out of that courthouse very quickly. Okay, Sydney Rushing, you are up next for the defense. So get ready. We're going to have a commercial break, so have you a little bit of time to prepare. It's like a little sidebar, and then it's your turn. What can we expect from the defense closing argument when we come back?
There was no collision with John O'Keefe. There was no collision. There was no collision. All that smoke and all those mirrors will not ever reach their burden. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide. By the end of this trial, you'll conclude that Karen Read is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all 3 of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty.
That was Alan Jackson in his opening statement, sort of making an argument earlier in the trial, the retrial. It is closing argument eve. Tomorrow you will see and hear the closing arguments right here on Court TV. Obviously, we'll be talking about it tomorrow night, unless we're talking about a verdict, which can happen at any moment. So don't stray from your televisions tomorrow or any day when this jury is deliberating. Right now, let's bring in criminal defense lawyer Sydney Rushing, who has volunteered to present a closing argument for the defense tonight here. Thank you so much, Sydney. Again, law and order rules, about 3 minutes of time. I know it's difficult, so we appreciate it. Are you ready?
I'm ready.
All right, counselor, the floor is yours.
Who else is sitting here thinking, what about? The missing pieces, the contradicting stories, the sloppy investigation, and most importantly, the proof that Karen Read struck John O'Keefe with her 6,000-pound SUV and left him there on the yard with no broken bones, no bruising, and no injuries to support being hit by a vehicle. Karen Read is innocent. Simply put, unlike any other aspect of this trial, the prosecution has failed to meet their burden. Let's quickly knock out count 1 of the discussion. To prove murder in the second degree, not only do they have to prove that Karen caused the death of John, but that she also intended to do it. There has not been one shred of evidence that Karen intended to hit John. I think you'll easily agree that the prosecution has failed to meet their burden on this aspect. As it relates to the remaining 2 counts, one of the elements that both counts share is that the Commonwealth must show beyond a reasonable doubt that Karen hit John with her SUV. And after 8 weeks of testimony, they've probably left you with more unanswered questions than giving you answers. First, and most importantly, you've heard many witnesses testify about the lead investigator in the case, Michael Proctor. What about Michael Proctor? Many of the reasons you likely have unanswered questions in regards to the evidence is because you're missing a key part of the entire case, the lead investigator. Let's talk about Aperture. The Commonwealth asked many questions about the defense paying the ARCA experts. But what about the Massachusetts State Police? They have an accident reconstruction expert, yet they weren't good enough to solve this case. So they paid Aperture $400,000 to show you the conclusion that they wanted. Did they not go with the Massachusetts State Police because it wouldn't turn out the way they wanted? On the opposite side, ARCA was hired by an outside source and came to their conclusions before becoming even a part of this process. You've heard testimony from Dr. Russell, who told you that these wounds look like dog bite wounds based on pattern recognition and her experience. Dr. LaPosada also told you she believed these wounds looked like animal bites or claw marks. Dr. LaPosada stated the wound on John's head came from something that had a little ridge to it and was irregular in shape. She said that John's body didn't have any bruises or broken bones, but it also lacked signs of hypothermia and frostbite. Dr. LaPosada said it best. The body tells her all she needs to know, and that John O'Keefe's body showed no evidence of being hit by a vehicle. I also think that the Commonwealth thinks that you're naive enough to think that someone being hit by a vehicle that's 6,000 pounds going 24 miles an hour in reverse would stand there, get hit, not make a sound, and have no broken bones and no bruising. I think we all know that we don't need a doctor to tell us what common sense tells us what injuries we would expect to see. So I leave you with this. What about the missing evidence? What about John's body having no broken bones and no bruises? What about the lack of investigation into all parties? What about the sloppy investigation with so many loose ends? All the whatabouts, those are all doubts. I ask that you use your common sense, and I'm confident that if you do, you will do the right thing and find Karen Read not guilty. Thank you.
Fantastic again. Wow. Like if this is America's Got Talent, you both get golden buzzers, by the way, just so you know. So
this is what we do.
Yep. So, Rebecca, as you're listening to all these points, I just love the general theme here, which is pushing everything onto the prosecution, taking no burden, and telling this jury over and over again all the things that you don't know.
Yeah, I think that's really effective. And, you know, I just want to say, Margaret, I think your presentation was effective because you did talk about the one really compelling thing that I agree that the defense didn't do enough necessarily to counter, which is the text stream data. They did bring up on cross that it is an arbitrary time that was assigned based on another event. And, you know, we're not even sure that it happened that day, that time, because that's not there. But I think what you did in your closing for the defense, which was really compelling, is you pointed to the fact that the prosecution had to go far afield to find people that would bolster their case, when typically all of those experts do work for the state in which they are prosecuting the case. That happened again and again and again, and that is absolutely something I would point out on closing. They were able to find one guy who agreed with this one thing, and then went to another one guy to agree with this one thing when they had this wealth of information available to them that they chose not to use.
And Sydney, what I loved was how you framed Michael Proctor, because I was thinking about this myself, and I didn't come to a crystal clear way of making it resonate. But if you tell this jury you've got questions, well, the guy with the answers wasn't called, and you know a little bit about, and they know a little bit about him, right? They know there's something really wrong with this guy. But to me, that's like, wow. There's unanswered questions because they didn't give you the lead investigator, never showed up inside this courtroom. That was amazing. I thought the $400,000, that's going to be huge. And I also like the fact that the whole theme is all about the burden that prosecutors, when I have seen successful defense attorneys on court TV, it's always about the burden. And you get the jury focused on, because it's a tremendous, I mean, Rick Grundy and Margaret, both as prosecutors, have overcome that burden many times, but it's not easy. It's not easy. I mean, you've got to really bring it, and there's some jurors that have a hard time understanding what it is. Cindy, how about your choice here with the dog bites? The dog bites I felt was sort of sandwiched in the middle. I think that's appropriate, but give us the thinking behind that.
So I think it was really hard to, knowing that I only had 3 minutes, I had to kind of pick and choose my battles between almost, 50 witnesses, right? Obviously, I wanted to go a little bit more into Michael Proctor. I wanted to go into more with Aperture. But I think that it's very important to show, because what we have here, the injuries we have, are John's arm. So the defense had to put those doctors up there to give another reason to how those got there, right? If they didn't call these two doctors and both say these look like animal wounds, right? How would the defense have rebutted the injuries on the arm? So we have to bring I wish I could have gone more into it, right?
Sure.
There's a lot more between these two doctors.
3 minutes.
Pick and choose.
3 minutes is impossible. Speaking of time, we're out of time, but I appreciate so much everyone coming on here and celebrating closing argument eve. Rick Grundy, Margaret McLean, Sydney Rushing, Rebecca Lavoie. We're going to have you back. I think we're going to be in a verdict watch early next week, so we'll speak again. Thank you so much. When we come back, folks, something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, the Karen Read case has been unlike any we have ever seen, with a public reaction unlike anything we have ever seen. Will this be the new blueprint for high-profile criminal defendants? We investigate. Time to reveal something else you need to know tonight. Let's take a look at the big board, and it's verdict day for Lrae Vallow Daybell. Third time around. Let's see if she did any better.
All right, the clerk will read and record the verdict.
In the Superior Court of the State of Arizona, in and for the County of Maricopa, State of Arizona versus Lrae Daybell, CR 2022-001242-001. Verdict count 1. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do find the defendant, Lrae Daybell, as to the crime of count 1, conspiracy to commit first-degree murder occurring on or about October 2nd, 2019, as follows. Guilty. Signed, foreperson. Are these your true verdicts, so say you one and all?
Yes.
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 And the Daybell has rung for the final time. We don't have to talk about her. Let's talk about a missing child who needs your help tonight. Take a look at your screens. This is Lrae Manurs. Lrae is missing out of Mesa, Arizona, 17 years old. Please pick up the phone, make the call if you see Lrae. You can call the Mesa Police Department. That phone number is on the screen, 911 or 1-800-THE-LOST. All right, don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.